Hello students, my name is Liz Attia and today's topic is the law and abortion. Okay, so the law and abortion. So abortion is defined as the termination of pregnancy by the removal or expulsion from the uterus of a fetus or embryo prior to viability. An abortion can, of course, occur spontaneously, in which case it's usually called a miscarriage, or it can be purposely induced. So in terms of the way that the law actually considers abortion, under the law, a fetus is not a legal person. So it does have some rights, but only where it's born alive. And the textbook actually talks about the born alive rule. I'll actually point you in the direction of those readings. It is important that you actually get your mind across the distinction there. The law presumes, and the onus of proof there is that the fetus is in fact born alive before those legal rights come into fruition. So legally, a person is not alive until he or she is fully born and completely derived from its mother's body and has in fact taken breath. So under the law, fetuses cannot be murdered, but if they are born alive and later die from prenatal injuries, the assailant may be guilty of murder or manslaughter. And have a look at the case of the state and the AG's reference, which is actually in your textbook on page 561. So in terms, I guess, of the legislation in Australia, the legislation differs from state to state. The ACT is in fact the only state in Australia where abortion is unconditionally legal. Every other state actually does have restrictions on the process on how abortion is actually undertaken, and also the time of when abortion can be undertaken. So in New South Wales, if we actually focus on our state for just a moment, in New South Wales, abortion is regarded as lawful if performed to prevent serious danger to the woman's mental or physical health. So the legislation prohibiting unlawful abortion is set out in the Crimes Act of 1900, and the legislation is actually contained in sections 82, 83 and 84 of the Crimes Act, and I'll actually ask you to go back and have a look at that in your textbook. So the default position is that abortion is illegal and only legal under certain circumstances. And those circumstances is to prevent serious danger to a woman's mental or physical health. So abortion must be necessary. And the defence of necessity comes into play to ensure that the termination must be necessary, so it needs to happen, and the termination must be proportionate to the danger to be avoided. What that actually means is that the law actually says there must be an evaluation of the danger which is alleged, and that must be proportionate to the danger by continuing with the pregnancy. So it's not enough, for example, for a woman to actually go to an abortion clinic and say, well, you know, I'm just not feeling like I can actually manage a baby today. There's a process of examination and assessment and evaluation to assess the level of risk. Having said that though, a gamut of reasons would actually, under the law, be considered acceptable to satisfy the defence of necessity. What that might be is psychological strain, financial pressure, emotional vulnerability, not being physically in accommodation that would be supportive of raising a child, not being psychologically or emotionally ready, parents who aren't supportive, a partner who's unsupportive, etc. So the threshold is not difficult to meet. But having said that, though, it does need to be assessed by the treating professionals in terms of its legitimacy in the eyes of the law. So there is a process by which the assessment is undertaken. So the position in New South Wales actually derived from the leading case on this particular subject matter, which was the Judge Levine case in the case of the State and Wold, which is actually in your textbook on page 565. And in this particular case is where legal precedent around abortion and the permissibility based on the defence of necessity came about. The judge made legal precedent on the definition of what was considered to be lawful abortion, stating that an abortion should be considered to be lawful if the doctor honestly believes on reasonable grounds that the operation was necessary to preserve the woman involved from serious danger to her life or physical or mental health, with the continuance of the pregnancy would entail, and that in regard to mental health, the doctor may take into account the effects of economic or social stress that may be pertaining to the time. I guess the only thing I'd ask you to actually consider, or not the only thing, but one extra thing I'd ask you to actually consider in your reading of this case is mentioning of the paternal rights and the considerations and the preparedness of the father for the fetus and how the father actually factors into decision making with respect to abortion. So the Judge Levine case has been affirmed and followed by the courts in New South Wales, and since 1971 there's been no prosecution for unlawful abortion, although in 2005 Dr. Sood was charged with manslaughter and procuring an unlawful abortion in New South Wales, and this is in fact one of the cases which we actually talk about in the tutorial case study booklet and we talk about in the seminar presentations. So Dr. Sood was convicted of the use of a drug to unlawfully procure a miscarriage, but was in fact acquitted of manslaughter. So the summary of the legal position, abortion is not always unlawful in New South Wales. The test for unlawfulness of abortion is whether a doctor reasonably believes that's necessary to preserve the health, the physical and mental well-being of the woman, and the risks with abortion are measured. Mental health has been interpreted broadly to include economic or social stress, and in fact in New South Wales you don't need a referral to attend a clinic for an abortion because they have internal processes that manage that. At a snapshot, these are the different laws in different states across Australia, and you'll note that there is some variance there, ACT being the only state where in fact it's unconditionally legal. And you'll note also the time difference as to the point of viability between early term and late term abortions and how that actually differs in terms of the legality. Thank you, students. That brings today's topic to an end.